Perfect. That's
Right.
great.
Okay.
Right,
Take it away, Jim.
Anne, can you move it on to the learning outcome slides? Right, folks, we'll get started with the learning outcomes. So, first of all, want to clarify the role of GTC Scotland with regard to fitness to teach, and also raise awareness of some crucial aspects of the process. In doing that, I'll explain the main stages of the fitness to teach process, and we'll clarify the importance of COPAC, the Code of Professionalism and Conduct, and what that actually means for lecturer conduct. We'll also clarify the sort of things that GTC Scotland would likely investigate and would likely not investigate as regulator of the profession, and we'll develop insight into the various factors that affect the fitness to teach process and affect the decision to investigate or to not investigate. Can I have the next slide, please, Anne? Okay, so regulation, otherwise known as fitness to teach. So a role in regulation is defined by the Public Services Reform Order of 2011, which gives us a statutory function to regulate the teaching profession on behalf of the public. And the important word there is regulate, not prosecute or punish. We very much have a neutral role throughout the whole process, overseeing the process and ensuring that the rules are applied fairly and proportionately at various stages of the process. The key aim of the process is to protect learners, and in doing so, to maintain public confidence and trust in the profession. New fitness to teach rules and a threshold policy were introduced in 2017, and the intention has been to make the process fairer and more transparent, with the rules and the threshold policy on the website freely available for anyone to access and see. It's also important to note that the 2017 rules have a solid legal underpinning, as they're approved by the Lord President in the Court of Session in Edinburgh, the highest court in Scotland. And this reflects the very legal nature of our processes with regard to fitness to teach or regulation. We regulate two areas. Those areas are competence and conduct. And today's presentation will focus on conduct, which, as you can see from the slide, accounts for by far the majority of our caseload, accounting for 90% of cases in 2021. Next slide, please, Anne. Thank you. So, when do GTC Scotland investigate teacher or lecturer conduct? The very first thing we ask ourselves is, does the referral meet the requirements of the threshold policy? Our threshold policy sets out what we would and would not investigate and details a lot of the thinking that goes into those decisions. In the context of college lecturers at the moment, a referral is likely to come from information that has come to light during the application process that may have a bearing on the applicant's fitness to teach. And as such, the majority of fitness to teach cases that are being dealt with in relation to college lecturers at the moment is in relation to applications. Although it could also be the case that we receive referrals from college employers or members of the public on a college lecturer's fitness to teach. And we'll come to some of that a bit later on. We investigate what is referred to as relevant conduct. So that's conduct that falls short of the conduct expected of registered teachers and lecturers. So conduct where there's a realistic prospect of a finding of impairment, and the behaviours where that would be the case are listed in COPAC. Separate to COPAC, it's also worth pointing out that we have various professional guides on our website that play no part in the regulation process, but do give some useful advice in areas that may be difficult to navigate for teachers and lecturers, such as the use of social media in meeting the needs of various groups of learners, e.g. dyslexic or autistic learners. And I would encourage you to raise awareness of those guides amongst lecturing staff, as it can be very useful for professional learning purposes. When we investigate someone's fitness to teach, The test is very much a current test. It's about impairment in the here and now. And that's why we have something called a 5-year rule, which means that we don't investigate something that happened more than 5 years ago, unless, of course, it is of a particular level of seriousness, such as a child protection issue, where we would have a duty to investigate regardless of when the incident allegedly happened. Our processes are intended to address the risk of harm and to protect. Openness, honesty, reflection and engagement are key aspects of the process. We recognise that professionals sometimes make mistakes. Teaching and lecturing can be particularly demanding jobs, and it would be impossible not to get things wrong sometimes. As stated earlier, the process is not about punishing professionals for mistakes made, but about ensuring that we have adequate protections in place so that learners are properly protected. Where a mistake has been made, it is therefore vital to be open and honest when engaging with the process and to reflect on what went wrong. Where this happens, there's a greater likelihood of a favourable outcome, and that would certainly be one piece of advice I would give for when you're supporting members. Where the allegation has been admitted or proven, insight into what went wrong and how things should be handled differently in future is a crucial element of that reflection. Next slide, please, Anne. Thank you. So let's now look at the conduct process in a bit of detail. And this graphic outlines the process from start to finish. The process starts with a referral. And as I touched on earlier, a referral can come in from a variety of sources. Could be from a member of the public, could be from the employer, it may even be from the courts or from Disclosure Scotland. When we receive a referral, it goes through the first stage of a process, which is initial consideration. So initial consideration is where the referral is initially considered by a member of the regulation team using a threshold policy. Now that's a very quick process, approximately 2 weeks. And in that period, we decide whether or not we need to investigate based on the information given within the referral. Reasons why we wouldn't investigate a referral at this stage include the conduct not representing relevant conduct. Perhaps it's already been considered after being received from someone else with different wording. Perhaps the referral is deemed frivolous or vexatious. It's important to note that these reasons can lead to the case against a teacher or lecturer being dismissed not only at this stage, but also at other stages of the process after having gathered more information in the matter. And it's interesting to note that 40 to 50% of referrals tend to exit at this stage. If it doesn't exit, we then move on to the investigation stage. And at this stage, the allegations within the referral are investigated by one of our regulation officers. And they spend a lot of time talking to witnesses, taking statements, gathering information, and finding out exactly what happened. Once the regulation officer has managed to pull all the information together, they fill out an investigation report, and the recommendation within the report will be that there is no impairment and the case should be closed, or that it needs to move on to the next stage. And that next stage, if it moves on to it, is panel consideration. So unless the regulation officer decides to close the case after investigating, it will move on to the panel consideration stage. At that stage, a panel meets in private, and all the evidence that has been gathered is examined by a panel, including any responses from the lecturer. A panel consists of 2 registered teachers and 1 lay member, ensuring a certain level of understanding of different aspects of education, which can sometimes be crucial when deliberating on a case and trying to reach a decision. Different options are open to the panel. It may be that they find no impairment and therefore no further action is taken. or a consent order may be issued with one of the following disposals. And disposals is simply our legal word for decisions. The disposals could be a reprimand being placed against the teacher's name in the register. It could be a conditional registration order, which is where the teacher is allowed to keep their registration, but certain conditions are placed on it to ensure that the teacher remains fit to teach. It could be a combination of both a reprimand and a conditional registration order, or the ultimate sanction, removal from the register. The panel could decide to refer the case for a hearing if they consider that to be necessary in the circumstances. And it's important to note that any consent order at this stage can only apply with the consent of the teacher or lecturer. If they do not consent, it automatically goes to a full hearing so that both parties can have their say. Now, if it goes to a full hearing, that is the final stage of our processes. And as I've just said, a case can reach that stage if the panel refers the case for a hearing or a consent order is issued but not accepted or signed by the teacher or lecturer. This is the opportunity for the evidence to be openly tested in front of a GTC Scotland panel. At a full hearing, you would have the presenting officer who would present the case for GTC Scotland. You would have the teacher or lecturer who's likely to be represented by a representative of his or her choice, perhaps a union official who's there to act in the best interests of the teacher or lecturer. The panel deliberating in the case, again, consists of 2 registered teachers and 1 lay member. At the full hearing, the panel will determine the facts of the matter based on the evidence, and applying the balance of probabilities, will come to a decision on the allegations. If some or all of the allegations are found proved, then the panel will determine the teacher's fitness to teach. Ultimately, the outcomes could be the same as the potential outcomes at the panel consideration stage, and those outcomes are no impairment and therefore no further action, a reprimand, a conditional registration order, perhaps a combination of reprimand and conditional registration order, or removal from the register. So that outlines the role of GTC Scotland with regard to investigating conduct through the fitness to teach process. And in the slides that follow, we will look at the role of COPAC and explore the type of conduct we would likely or not likely investigate as regulator of the profession. But before we do that, we'll pause for a few seconds to give you the opportunity to gather your thoughts and to ask any questions that you may have about a process with regard to conduct. So questions here to do with the conduct process are the main drivers. We'll be looking at what we investigate and what we don't investigate in the next few slides. So if we can stay clear of that topic for just now and just concentrate on the process and the main drivers of the process that I've talked about there. Any questions? Thank you. Okay, so COPAC, right? COPAC is a key point of reference when investigating professional conduct, as it is used to base decisions on whether a referral about an applicant or a registered lecturer relates to conduct that would meet the test of relevant conduct that I referred to earlier. So what I want to do now is give you the opportunity just to shout out the sort of things that you think would come up in COPAC, because I'm going to move on to that in a bit of detail, and I'm interested to see what knowledge is out there first. So if you just tell me what sort of things, what sort of behaviours or conduct would come up in COPAC.
2 things. One, you can shout out there. Jim's also in his slide there mentioned that you could dip that into the chat there if you've got any ideas or anything you want to put in there, or if you want to just speak, stick your hand up and we'll introduce you.
John, anything in the chat? Can you keep me right with that?
Here we go. Giving students answers, Jim.
Giving students answers and assessments, national assessments, I'm assuming?
I would guess so, yeah.
Yep. Okay, yep. Anything else coming in?
Anything else, folks, or anybody want to put their hand up? What does COPAC stand for, Jim?
Code of Professionalism and Conduct.
Okay. Bullying.
Bullying is an interesting one, and one of the slides we're going to look at later on is going to actually touch on that. But certainly if there's evidence of bullying, it could be something that we could investigate.
Prejudice.
Yep.
Inappropriate relationships.
Yep. Some of the big hitters are coming in now.
Anything else, folks? Does anybody want to? Here we go. Violence.
Violence. Again, an interesting one. Yep. And that would likely be investigated. We'll leave that there, John. That's a good starter. So thanks for that.
Here's a wee quick one, Jim, which might connect to some of those social media use before we stop. Yeah, that okay? And that's, yep.
Perfect. And that is another very interesting one, which we'll touch on in the slides. Okay. And can I have the next slide, please? Okay. This slide here talks through the key principles of COPAC. And it'll pick up on some of the things that were mentioned in that last slide. And I would ask you to pay particular attention to any that didn't come up when considering the key content of COPAC. So there's 5 parts to COPAC as follows. Part 1 is professionalism and maintaining trust in the profession. And that's about having knowledge of and maintaining the key principles in GTC Scotland documents, such as the professional standards in COPAC itself. It's about maintaining appropriate professional boundaries and avoiding improper contact or relationships with learners, which was mentioned. It's about avoiding situations within and out with the professional context, which could be in breach of criminal law or may call into question your fitness to teach. It's about upholding standards of personal and professional conduct, honesty and integrity. It's about acting with integrity in your dealings and correspondence with professional bodies. And it's about being a good role model to learners in all that you do. Part 2 of COPAC is entitled Professional Responsibilities Towards Learners. And that's about treating sensitive personal information about learners with respect and confidentiality. It's about being truthful, honest and fair in relation to information you provide about learners. It's about motivating learners to realise their full potential. It's about maintaining up-to-date knowledge of and complying with child and protected adult protection procedures. It's about raising any concerns you may have about the behaviour of a colleague in connection with a child or protected adult. And it's about being aware of the general principles of the United Nations Convention on the Rights of the Child and ensuring that you act in that awareness so that you're acting in the best interests of learners. Part 3 of COPAC is entitled Professional Competence. That's about maintaining and developing professional practice to ensure that teachers and lecturers meet the appropriate professional competence requirements. And it's about refreshing and developing your knowledge and skills through appropriate professional learning. Part 4 of COPAC is entitled Professionalism Towards Colleagues, Parents and Carers. That's about working in a collegiate and cooperative manner with colleagues and other professionals. It's about treating all colleagues, parents and carers fairly and without discrimination. It's about not making malicious or unfounded criticisms of or accusations about colleagues that may undermine them professionally. It's about promoting good relationships between home and the learning community and respecting the role of parents. It's about taking great care when expressing opinions in public about your employer and being mindful of Data Protection Act requirements, now of course superseded by GDPR requirements with the information that you hold. And part 5 of COPAC is entitled Equality and Diversity. That's about engaging and working positively with learners, colleagues, parents and carers in an open, inclusive and respectful way. It's about helping learners to understand different views, perspectives, and experiences. And it's about being aware of the potentially serious impact that any demonstration of intolerance or prejudice could have upon your standing as a teacher or lecturer in your fitness to teach. Okay, next slide please, Anne. So those are the main behaviours identified by COPAC, and there was a lot of information in that last slide. So what we're going to do now is look at some mock scenarios and try to apply what we have just been learning about the content of COPAC. What I want you to do here is to decide whether GTC Scotland would be likely to investigate such a scenario or not. And also, if you can, give reasons as to why or why not we would be likely or not likely. This section is all about developing your thinking and understanding. So just come right in with answers. It's not about right or wrong answers. So simply go with your gut if you're unsure, and it'll help to generate a bit of discussion so that we can look at the main points and build our understanding of the different factors that are involved when we're looking at someone's fitness to teach. Okay, so first scenario, next slide please, Anne. A lecturer gets intimately involved with one of his or her students when out on a Saturday night, investigate or not. And I would simply ask you for this, either to unmute, John, if you can keep me right with the chat facility again, so
Yep.
either unmute or chat facility. Thanks, John.
I'm getting a few yeses in the chat at the moment, Jim.
Yep.
Anybody want to add anything? If you do want, just stick your hand up. I'll keep an eye on things. There's a few more yeses and a no.
Right, okay.
No more comments, Jim. What do you think
Okay.
then?
Right, we will move on with the answer for that one. And glad to see it was by far a majority of yeses, because we would likely investigate this sort of scenario. It falls under COPAC 1.2. It's deemed as not maintaining appropriate professional boundaries. There are ethical questions here around relationships and the sort of relationships that are appropriate for lecturers to engage in with students. It's not just about age, which can make things clear-cut in a school setting, for instance, but there are other factors, such as the power differentials that exist in certain relationships. Sort of thing we would be looking at is, has the lecturer taken advantage of his or her position? Has there effectively been a degree of grooming? We have to consider such issues when looking at these sort of things and look at the bigger picture. Remember, that bigger picture also includes protecting the reputation of the profession, so that the profession continues to be held in high regard in the eyes of the general public. So it's about protecting that sense of professionalism in your professional standing as a college lecturer in Scotland. And it's only by looking at these sort of scenarios that can be protected. Okay, I'll move on to the next one. A lecturer passes on information to an examination awarding body that a learner has passed all coursework when that is not the case. Investigate or not. And John, if you can keep me right again.
Okie doke. Again, if you want to comment in the chat, I'll pick those up there. At the moment, I'm getting a mixture. I've got a no and a number of yeses.
Okay.
I've got a yes with a question mark.
Yep.
Yes with two question marks.
Anything else coming in, or anyone offering to comment?
Somebody's given us, I would say no, as awarding body has authority, but not sure. A couple of maybes, right. And mistakes happen.
Yep. And that last one is a very interesting one, and you'll see why with the answer. Mistakes happen. Because yes, we would likely investigate this sort of scenario, It's deemed as not upholding standards of honesty and integrity, which is COPAC 1.4, and also not being truthful, honest and fair in relation to information you provide about learners, which is COPAC 2.2. But as was said, mistakes happen. So intention would be an important consideration here. And it's important to point that out. It may be that the lecturer passing on the information didn't do so deliberately and that it was a mistake. If that is clear from the information in the referral, we would likely not investigate, and the case would be dismissed at initial consideration. Equally, if we don't have that level of detail, we would likely have to investigate, but could close the case down if that becomes apparent during the investigation. Often we need the lecturer's input for this type of evaluation, and that often doesn't come until we investigate the detail. The detail is important. As said earlier, our processes are not about punishing professionals for mistakes made, but about ensuring that learners are protected moving forward, and that the reputation of the profession is also protected.
Could I maybe come in there, Jim?
Yep. Go for it, John.
I'm just thinking of that. I mean, I've represented people in situations like this where it has been a mistake, and what would happen, or what has happened there, is a thorough investigation happens at college level.
Yeah.
They come to a decision whether they believe or not. It would be possible, I would guess, that could happen, and then there would be another investigation by GTC. Would that be possible?
It would be possible if at college level they came to the decision that they think it's not a mistake. If they think it's a mistake at college level, really there's no reason to send a referral into us, none whatsoever. Does that clarify it?
Yeah. So, but if they did think, if they thought it wasn't a mistake,
at that point they would likely send in a referral for the reasons there. As I say, it's if it's not a mistake, then it is not upholding standards of honesty and integrity. So that's their judgment call at that point in time. We would then look at it and we would do a thorough investigation. Our regulation officers are trained in investigative practices. So when it comes to the investigation that we do, and this maybe goes back to one of the earlier questions as well, there's people with different abilities and different training in the different colleges all over the land. But certainly there's a certain level of consistency when it comes to the investigative practices carried out by GTC Scotland. Our regulation officers are trained in that, and they would be able to get behind the key detail and get to the bottom of exactly what was happening there. And
see that referral, Jim, who could that come from? Obviously, the employer may be one that could send that. Could anyone else send that referral? I'm thinking, for example, if a member here was unhappy with the decision that they had taken. Right, now that can lead to disciplinary measures being taken, but obviously it's a double-edged sword going to GTCS, but with the experience that you've just outlined there, some people may feel that would be beneficial for GTC to make a decision on that. Basically
a member of the public. So anyone can be classed as a member of the public.
Right.
So any member of the public could send in a referral. When we receive a referral, it would be from the employer. So if it was a school and a local authority, for instance, the referral would tend to come from the local authority, who's the employer. But there are times when we do receive employer referrals, and we put it through, we even dismiss employer referrals at initial consideration. So not all employer referrals get investigated. So that's the first thing. And the second thing is that even if it does move on to the investigation stage, employer referrals, after we have done a full investigation, we could disagree with any outcome that they came up with at local authority level. And that happens. That definitely happens within the system. As I say, we look at things from the point of view of fitness to teach, and we have consistent processes for doing that. Similar to what I said about colleges, there are 32 local authorities. So again, across the country, you're going to have inconsistencies. So there are times when we receive a referral from an employer and we dismiss that referral after an investigation.
So I'm just, sorry, thinking out the box here, but just imagine you get a particular organisation where there's a number of referrals and time and time again, you dismiss it.
Yeah.
What would the GTCS position be, you know, regarding that? Or do you not have?
Well, that's in fact one of the joys of my job, Alison, because I meet with the local authorities on a regular basis. Now, it's dependent on local authorities taking up the offer of a meeting, but I meet with them on a regular basis, and if there are issues regarding the process, it's an opportunity to have a discussion about exactly what is going on there. Sometimes it can be down to a misunderstanding, and things can be very quickly and very easily cleared up, and it means that in future we then don't tend to receive these referrals that we shouldn't receive.
Okay.
Does that answer it?
It does to an extent, yeah. Thanks, Jim. Cheers.
Okay.
Okay, Alison. Yep. Another wee question just popped in here, Jim. Could GTCS raise this with a boarding body? Come back to your, you know, the item we're investigating there. Yep.
We wouldn't raise it with a awarding body. We would look at exactly what happened in that scenario. So trying to think if there would be any reason for us to actually contact the awarding body.
Potentially to give evidence, I suppose.
Possibly for information on what happened. So that would be a possibility as part of the investigative process. It is a possibility, but it would really depend on the case, John.
Yeah. Okay. Okay. I think that's everyone there. Anybody get any other comments, folks? Are we all happy with that one? When you go, Jim, that's good. Thanks.
We'll crack on with the rest of it. Okay, brilliant. So next scenario, a lecturer regularly, that was easy for me to say, turns up late for work in the morning and for different classes. Would we investigate that or not? And this is similar to something you said at the very start, John, now that I think about it.
I'm getting quite a few no's here. We've got at least one yes.
Right.
I've got HR internal issue.
Yep.
Got another yes. Another no, this would be up to HR to raise with the lecturer.
Yep.
Anybody get any other comments in there? No's or yeses? Hand over to you, Jim.
Right, perfect. I'm aware of time, so I'll just press on. Can we have the next slide, Dan? And the answer here is that we would likely not investigate. It is deemed a matter for the employer. The only exception may be if a learner is harmed because the lecturer is not where the lecturer should have been. Remember, one of the key drivers of the process is the protection of learners. But there are certain things that are deemed a matter for the employer and will always be dealt with at that level without the need for GTC Scotland to be involved. And this is one of those scenarios. We are legally required to carry out the fitness to teach process in a way that is proportionate and targeted, and to only take action where necessary. And this is an example of conduct that can be managed by the employer, and it would not be proportionate for regulatory action to be taken. If a learner were harmed, however, because the lecturer had neglected his or her duties, it then becomes more serious, and at that stage we may receive a referral on it.
And I think a gold star for Leonard, virtually word for word, just before your slide appeared, he had banged in there HR internal unless the student have been exposed to harm.
Fantastic, well done, Leonard. Right, next one, can we have the next slide, Dan? So, two colleagues do not get on to the extent that they do not work together in matters of mutual interest, like sharing of resources and planning for shared classes, which ultimately has an impact on learner attainment. Would we investigate that or not? What do you think?
Okay, we get yeses or no's, and Leonard's just telling us that you get the credit, Jim, because he did learn. He was at your presentation last week. So that's good. Learning is happening.
Question. Yes.
Yep, so I've got a selection of no's and a selection of yeses. I've got a yes and a question mark. Yes, but only if the college can't deal with it. A comment there about impact on learner. And then some more yeses and no's. So we get a mixed response here, Jim.
Right, so this is a good one. And can we have the next slide, please? And this probably touches on the question earlier about bullying also. As I said, that would come up. This one would very much depend on the circumstances, although initially it would be dealt with by the employer. So initially it is deemed a matter for the employer. Even though Part 4 of COPAC is about professionalism towards colleagues, the employer is best situated to make a judgment on exactly what is happening between two professionals in this scenario. We would therefore have to be proportionate, and it would be better for the employer to investigate and then determine whether the conduct is the conduct we would expect of a registered lecturer, and to decide whether anyone should be referred to GTC Scotland for behaviour that would be considered relevant conduct. So if there's any sort of intimidation or prejudice or any relevant conduct that would not fit with what we would expect, then we would look into it if we received that referral. Okay. Next slide, please, Anne. And I did say we would get onto social media. So at the weekend, the lecturer posts a message on social media verbally abusing colleagues they work with and criticising students they teach. Investigate or not? And if you can keep me right again, John.
Yep, I'm getting quite a pile of yeses. A yes with an exclamation mark.
Yep, good stuff. I think this one is pretty clear cut. Since we're running slightly behind, so I'll just move straight on. So next slide, please, Anne. Yes, we would likely investigate. It's deemed as not being an appropriate role model, COPAC 1.6, and not upholding standards of personal and professional conduct, 1.4. Could also be in breach of 2.1. You must treat sensitive personal information about learners with respect and confidentiality, and could be in breach of making malicious or unfounded criticisms of or accusations about colleagues that may undermine them professionally, which is COPAC 4.3. Professionals really need to be careful with their use of social media. You shouldn't go posting anything online that could be perceived as malicious or just having a go. Reputation matters and the perception of others matter, so professionals always need to be aware of that. They may not be at work when they post, but they're still recognised as a professional person by many people, and sometimes that means being held to a high level of accountability, whether you're at work or not. It's often said that when you're a teacher 24/7, and the same principle would of course apply to lecturers when gauging someone's fitness to teach. That can be particularly so in the case of social media, because of how comments, posts can be perceived by others. Also, once you post something, you no longer have control over it, and it can be manipulated or used by others online for their own purposes. So lecturers and other professionals really need to be careful with their use of social media and need to think about what they are posting. Next slide, please.
Two or three wee comments here, Jim. One is, yes, but after the college does the investigation, has been mentioned there. Does it include WhatsApp? I presume it's an encrypted system, I suppose, and it tends to be more private.
Yep, it could include WhatsApp, so I'll just quickly deal with that one. I can think of a situation where it did include WhatsApp. So even though it's encrypted, if messages on WhatsApp were to come to light, then...
They often do, yeah.
Yeah.
Mm-hmm. People take screenshots.
Exactly.
And then Couple of wee questions there about where can we access the full COPAC points. George put in the link to the GTC website and we've got that there. Okay.
Perfect, brilliant. Okay. Right. Situations that may be investigated. So this slide pulls a lot of the information from the previous section together. And it lets us see the sort of things that GTC Scotland would likely investigate as a professional regulator. The situations are informed by the conduct referred to in COPAC, and thanks for putting that link in there, George, and are listed in the threshold policy, which explains what we would regard as relevant conduct and the different factors that influence that thinking. Abuse of a lecturer's position of trust, I'll just quickly go through them. Forming inappropriate relationships, behaviour of a violent, aggressive or threatening nature, sexual misconduct or indecency, behaviour which demonstrates intolerance or prejudice, substance abuse and misuse, misuse of social media where it relates to a lecturer's practice, displays discriminatory or intolerant views or includes abusive or offensive language, fraud or dishonesty or other serious activities which cause harm and affect public confidence. You will see that the behaviours listed here are of a particular level of seriousness, and there's good reason for that. When we're considering taking action against a professional person regarding their fitness to teach, we're talking about someone's livelihood possibly being at stake. So it's a serious business with serious consequences. We therefore have to be proportionate and ensure that we are acting in cases where we need to act to protect the public interest and to protect learners and also the reputation of the profession. Should also point out that employers have a legal duty to refer a matter to us under circumstances where they have dismissed the lecturer due to misconduct, which may very well be the case with the situations mentioned on this slide, or where the lecturer stops working for the employer under circumstances where they would have or might have dismissed the lecturer for misconduct. That's a legal requirement for any employer and one that everyone should be aware of, so that it doesn't come as a surprise when an employer makes a referral under such circumstances. Next slide, please, Anne. There are different factors that would inform the decision to investigate or not, and these include the age of the behaviour. And I mentioned this earlier. If it was over 5 years ago, unless it was of a high level of seriousness, we would likely not investigate. We would also look at the degree of harm and ask if the harm was real and probable. If it were, we would be more likely to investigate. We would ask if this was a one-off incident or if it's part of a pattern of behaviour. If part of a pattern of behaviour, it could be indicative of more serious underlying issues, which may very well affect someone's fitness to teach. Give me a second, I'm just getting a warning, my battery is running low. Right, that's that sorted. So driving under the influence, for instance, may not be considered as serious if it's a one-off incident, which is totally out of character, but if it has happened more than once, it could be considered more serious. And if a student was in the car at the time, it may be considered even more serious again, because a student or young person could have been at risk of harm due to the lecturer's actions. We would ask, has the behaviour been addressed and is it likely or unlikely to happen again? Remember, fitness to teach is about the here and now. We will look at what steps have been taken, basically do a risk assessment of current circumstances. Remember that key considerations in any case that we look at are openness, honesty, reflection and insight. As mentioned earlier, we accept that professionals sometimes make mistakes. Some mistakes can be more serious than others, however, and there are certain things from which there's no way back, but a lot of the time there's a chance to remediate and to learn from any mistakes made. Throughout our processes, we therefore expect lecturers to engage, to be honest when reflecting on incidents, and to show insight and learn from any mistakes made, so that such mistakes are unlikely to occur again. Where this is the case, there is more chance of a favourable outcome. As I said earlier, it's not about punishing lecturers for mistakes made, but about ensuring that learners are properly protected and the reputation of the profession is also properly protected. We would also consider intention and would ask, was action deliberate or was it a mistake? If it was deliberate, it would of course be treated more seriously. And we would look at whether it was a system failure, a failure on the part of the individual. If it's misconduct on the part of the individual, we may look into it. We can only investigate registered teachers and lecturers, so only individuals. But if it's a policy failure or something to do with the lack of support, then that is more of a system-wide issue, and it's something for the employer to look at. It's not for us to look at. And not likely to be investigated. Lateness, poor timekeeping, abandoning post unless this has harmed a young or vulnerable person, personality conflicts are similar between colleagues where there's no evidence of bullying or harassment, smoking tobacco contrary to an employer's policy, misuse of work property for personal use, minor plagiarism, and fixed penalty notices unless learners were involved and were at risk of harm. And these examples are all listed in the threshold policy. And they're mostly issues that would be dealt with by the employer. Next slide, please, Anne. And this is time to stop for questions and for a comfort break. So basically what we're going to do now, we're going to look at some real life case scenarios. And again, there's no right or wrong answers. This is totally about developing insight. So it's about helping me and understanding a lot of the factors that come into play when we're deliberating in these cases. So, as I say, no right or wrong answers, just go with your gut and it'll encourage a bit of discussion and it will help to develop that insight. When it comes to a panel consideration or a full hearing, a reminder of the possible disposals or outcomes, and it is that no impairment is found and therefore no further action. It could be that a reprimand is placed against the teacher's name in the register. It could be a conditional registration order where the teacher is allowed to keep their registration but certain conditions are placed on it to ensure that that teacher remains fit to teach. It could be a combination of both reprimand and conditional registration order, or it could be removal from the register. At the panel consideration stage, that only happens with the consent of the teacher or lecturer. If the teacher or lecturer did not consent, it would automatically go to a full hearing to ensure that they were able to have their say, and it would then be heard at a full hearing and a panel would deliberate in the matter. So we can move on to the next one, Anne. And this is the first case we're going to look at in the breakout rooms. This case involved a range of behaviour, including making inappropriate comments to pupils about the school, other teachers, the curriculum for excellence, and the Scottish independence referendum. The teacher was also alleged to have sworn in front of pupils. A significant part of the case involved the teacher's conduct towards colleagues. So what do you think the disposal would be? But even more importantly, what are the key factors? What are the key things to consider here when deliberating on this case? What do you think? There we go. This may surprise you, but in this one, the teacher was removed from the register and is prohibited from seeking re-registration for a 2-year period. Now, it was mentioned in the chat that context is crucial, and a lot of the reasons as to why the outcome was so severe here was down to the context. The teacher admitted allegations, and given the severity of the pattern of behaviour, a removal with consent order, so was it panel consideration, because the teacher consented to it, was issued, and the teacher's name was removed from the register. The teacher had serious mental health issues, which in spite of treatment had not been addressed, and there was a very real likelihood of similar behaviour reoccurring, and there was the important context. Likelihood of reoccurrence is a crucial consideration in all cases, because if that likelihood is still there, then learners are still at risk of harm, and a disposal or decision has to be reached that protects learners and is seen to protect and also protects the reputation of the profession. The issues in this case were in fact so severe that the teacher's name being publicised would have led to a very real threat of suicide, according to medical evidence. So the case was therefore anonymised. Cases being anonymised are not the norm, because we have to have due regard to the public interest that's in the order that set us up, and the public interest demands transparency. But the possibility is there if there is a real danger of harm to the teacher or lecturer by naming them. In such circumstances, the danger to the teacher or lecturer has to be weighed up against the public interest. And in this case, the danger was so severe that it outweighed the openness and transparency that we would normally expect to see in cases.
Okay.
So that may come as a surprise, but certainly a few important points in there.
So you just come back, Jim. See if you go back to the slide. There was just one wee could you go back there, Anne? Just one wee bit in relation to the teacher had serious mental health, which in spite of treatment, so it had been getting treatment, had not been addressed. What would that mean? That, I mean, they're getting treatment, but had
the
not
mental
been
health
addressed.
issues were still there. Just as simple as that, John.
By whom? Who would have not addressed it? That's what I mean.
It wouldn't be us. It's the medical profession. So whichever medical professionals were treating the teacher, they hadn't managed to come up with any sort of solution to the mental health issues that the teacher had at the time. And that's why there was such a likelihood of reoccurrence moving forward. And the sanction had to be so severe in this case.
Okie dokie. I don't have anybody else desperate to come in there, Jim, so take it away with.
So next scenario, case 2. In this one, because of time, we're just going to use the chat facility. We're not going to go into a breakout room for this. So the teacher was found to have lied to his employer regarding the reason for requiring time off school. The teacher had told his employer that he was needing to bring his wife home from hospital, when in fact he was supporting a friend who had been convicted of child sexual abuse in court. What do you think the disposals would be? And just use the chat facility, and also what are the main considerations? Okay, we'll move on with the answers. So next slide, please, Anne. And your thinking was bang on for this one. It was a conditional registration order and a reprimand for 18 months. But the context, the teacher had originally denied the lie when confronted by the head teacher about his whereabouts, but then admitted he had lied when an internal investigation was conducted by the local authority. He then showed remorse and cooperated fully. Now, it was dishonesty, so it was not upholding standards of personal and professional conduct, honesty and integrity, so it is the sort of thing that would be referred to as. The GTC Scotland panel considered that there were mitigating circumstances and that the friend had previously been supportive of the teacher and his wife in a time of need, and also considered that the conduct was remediable and that under the circumstances, a reprimand would satisfy the public interest. In this case, however, the teacher was already on a reprimand due to a previous misdemeanour, and a more severe disposal was necessary to satisfy the public interest and to protect the reputation of GTC Scotland as a regulator. A couple of things that I'll pick up on. The teacher showing remorse and cooperated fully, showing genuine remorse, cooperating fully, demonstrating insight and reflection into what you've done wrong. As I've touched on already, those are key considerations in any case. They're important elements of remediation and of demonstrating to a panel that the likelihood of harm moving forward is low. It's the likelihood of harm moving forward that really we would look at. It can be about learning from situations, but that learning has to be genuine so that there is a low risk of harm moving forward. And also the fact that they were already on a reprimand, so you were right with your thinking. saying reprimand, but the fact they were already on a reprimand meant that there had to be a more severe sanction in light of the previous misdemeanour, and that's why it was a reprimand and conditional registration order.
Couple of wee comments there in the chat, Jim, that might, one is, what would a conditional registration order involve? And also, somebody's commenting they're surprised that it went to the GTCS. Would that have been referred by the authority to GTCS, such a case?
Yeah, I'll deal with the second one first. It would have been referred by the authority, as I say. COPAC 1.4, not upholding standards of personal and professional conduct, honesty and integrity. Blatant lies like that are the sort of thing that can easily be referred to GTC Scotland. Kids weren't getting educated because this teacher had lied about their reason for not being at school. That sort of situation would be referred to GTC Scotland under COPAC 1.4, and certainly to my mind there's good reason for that. What was the first point again, John?
What would a conditional registration order, what's involved in that?
Yeah. This one, I'm trying to remember the detail of this particular one, but basically I think because it was to do with dishonesty, yeah, it's coming back to me. It was to do with dishonesty. The teacher for that 18-month period had to produce an action plan outlining how they were going to tackle these issues with dishonesty moving forward. So that was one element of it. And the second element of it was 3 reflective pieces submitted to GTC Scotland on situations where dishonesty could have been an issue over the course of the previous school term and how they had dealt with those situations. So it's really getting that reflection about the importance of being honest and making sure that the registrant remediates in that way and learns about the importance of not repeating this sort of behaviour.
So somebody said, yeah, so they gave him homework. That's pretty cruel.
Homework, exactly.
Yeah. And somebody will have checked it, I'm sure. Okay. Okay.
I'll say as well, because I've had that comment a few times with this one about they gave him homework, but just to give a full picture of a conditional registration order, I mean, there's certainly been, I can think of one case where it involved alcohol, and it was affecting the teacher's fitness to teach. It went all the way to a hearing, and the panel imposed a conditional registration order, but in this case, it was more medical procedures. So the teacher actually had to get blood tests every couple of months to show and get reports for their GP to show that alcohol was no longer an issue, that they had fully remediated. So it varies depending on the circumstances, is really the point I'm making.
Okay. On case 3 there, somebody's already jumped it before you've even got to introduce it, Jim. 5-year rule, but not honest.
You know what? We are running short of time, so let's not bother with the chat out rooms for this one. Let's just go to it. If someone is saying 5-year rule, so an applicant for registration had been convicted of a number of decades ago of an assault, sentenced to imprisonment, failed to declare this in the application for registration. So I wanted to bring a college one in here. Any other thoughts on this one?
Spent conviction.
And it's the years as well. How many years was it? But if he's lied, then he could actually be removed from the register for that, could you not?
Because
if it's within the 5 years.
Yeah, dishonesty is recent.
Yeah. And that is a good point.
So we've got 5-year rule, but not honest. Spent conviction. Dishonesty is recent, and we're in a rush, Jim. I think it's the fact he's lied.
He's lied about something serious, yeah.
Answer, please, Anne. So basically, no impairment was found. And the reason for that is that the applicant provided a response explaining the circumstances of the offence and showing insight and remorse. It was more of an oversight than a blatant lie when when we actually looked at it in a bit of detail, so it wasn't treated as dishonesty.
And I suppose there, Jim, that highlights comment you made earlier about context is everything.
Yeah, absolutely.
Yep.
Yep.
Yeah.
Yep.
But that was certainly a very good point, and it is down to the detail in the case, and as John says, the context. I would spend a lot of time looking at these things in detail, making sure we have all the facts before deciding on, before sending it on to a panel. It's not us that actually make the decision, it's a panel that makes the decision. As I say, we play a neutral role, gathering all the evidence, but the panel then makes the decision, but we make sure that all the facts are there and they have all the information.
Interesting.
Thanks, Jim.
Okay, and final one, and we will go with a breakout room for this. Are we okay for time? Yeah, right, so this one, the panel issued a reprimand with consent order for 12 months. So it was with consent. So in other words, it happened at panel consideration stage. There were strong mitigating circumstances in this case. The teacher had been verbally abused and feared for the safety of his wife, himself and his friends, another couple, due to the aggressive nature of the abuse. At one point, he kicked out, causing the other person to fall and bang his head. The teacher was arrested, fully cooperated with the police, and reported the incident to his employer the next day. So that was important, totally upfront and totally honest about what had happened. He engaged with the local disciplinary and GTC Scotland processes, and the incident was considered to be a one-off incident with no likelihood of reoccurrence. It was therefore considered that there was no threat to the public interest and that a reprimand with consent order would suffice. So we can see that the teacher cooperated fully at all stages of the process and was genuinely remorseful at getting caught up in the incident, and that's really what happened. It wasn't something that the teacher started, they were caught up in the incident. Remember, risk of harm moving forward is a key consideration. And even though the behaviour was violent, if taken at face value, that is something that we would always have to consider, because if that's in your nature, it could then happen in a classroom or in a lecture room. And the reputation of the profession, as well as learners, have to be protected. So sometimes it's about preventative action to make sure those sort of things don't happen. And the teacher in this instance, however, was provoked, was acting in self-defence. And in this case, the public interest could be satisfied that this was not a violent person, and therefore there was a little likelihood of reoccurrence. And that's why it was only a reprimand.
Thanks, Jim.
Any comments or questions? I mean, the next slide is where Sonia is going to come in. But Anne, if you can actually move on to the final slide while we're taking comments and questions. And basically that's my details up there. So work email address and work mobile number. As I mentioned earlier, basically I can give advice on different matters relating it to a process at different times. So if there are any questions regarding anything moving forward that you just want to check process, obviously I can't give advice relating to specific cases. That's for you guys as in your role as branch secretaries to actually deal with for your members. But anything regarding our process or just to talk things through, then I could be at the other end of a phone just to talk through any issues. So that offer is there, and the details are on the screen if you want to take a note of them. And I will take any questions.
Jim, can I just say, we'll send out Jim's details. We'll also send out COPAC and any other relevant documentations around the group with the slides. So don't worry if you didn't get them down at that point. I'm just wondering, John, sorry, I'm abusing your function here. I'm just wondering if we maybe bring Sonia in and then do questions for Jim and Sonia as a kind of one-off, just mindful of time there.
That'd be okay. You okay with that, Sonia?
That's great.
You okay with that, Jim?
Yep.
Sonia's going to come in as a legal to offer some sort of advice on. Well, I'll not say. I'll shut up and let her speak. That's what I should do.
Thanks, Sean. I know some of your faces, some people haven't met before, so just to say I'm one of the two EIS solicitors in-house, the other being my colleague Laura, who some of you might have met before as well, or certainly spoken to in the last years, because that's how things work now, isn't it? So a large part of our job is to support members who receive notice from the GTCS that an investigation has been opened into their fitness to teach. So these notifications of investigations. And clearly up until recently, we would be assisting school teachers in responding to those notifications. So EIS members who are already on the register of teachers who receive notifications saying they're going to be investigated and following a referral that's been received from someone. So as we've said, that someone might be their employer, but equally could be anyone else. It could be the police, it could be simply be a member of the public, an aggrieved parent, often you might see with school cases. Clearly the situation at the moment is different for lecturers, and as Jim has explained, the GTCS may decide they have to investigate a lecturer's fitness to teach before they've even registered them, whilst due to something that's been triggered in their application, something they've said in their application for registration. So Laura or I will take on a member's case, be it a lecturer applying just now or a teacher who's already registered, from the point that they receive that notification of investigation. So as Jim said, you'll have cases where the referral's been received by the GTCS, they decide not to progress. We never know about them, but when the notification of investigation comes in, we can start supporting members. So in normal circumstances, a member is only going to have 14 days from the point they receive that notification to provide an initial response to the GTCS. The turnaround time is really tight. So the first thing that I'm asking of you today, there's only two things I'm going to ask of you, is that we need to hear from members just as soon as possible once they've received those notifications. So we'd ask that you pass on their details. So if a member contacts you to say that they've received the notification, we ask that you get in contact with our colleague Lindsay, and I'll make sure that Lindsay's details are sent out to you, Lindsay MacArthur, as quickly as possible, so that Laura or I can make contact with the member and start working with them to frame a response to the allegations that they face, or allegation if there's just one. And of course, we've not got long to do that. We've just got those 14 days. So as I say, we'll send on Lindsay's details, but it's really important, it's really best that you contact Lindsay. You might have worked with Laura or me before, so you might think of us first, but of course there's two of us, so one of us might be at the office. Laura has been the last week or two. One of us might be on holiday. Make sure you get it to Lindsay, then our department's got the information and we can deal with it from there. When referring that member to Lindsay, if you've got the GTCS paperwork that's been sent to the member, and usually these days it does seem to be by email, Jim could probably confirm that. So if you've got that documentation, pass that all on to Lindsay as well. The member will receive the notification of investigation. There's a fitness to teach booklet, which clearly we don't need that, but there's other forms as well. So if anything they've got, they just pass it on, then we've got that. And as well as any other information that you might happen to have on that member's case, just fire it all on over. We need as many of those 14 days to respond as possible, because we try to provide as much relevant information to the GTCS at the outset as we can, if the allegations are clear enough for us to actually be able to do that. Our aim's to work together with the GTCS to make progress at an early stage, and as we've said a number of times today, context is absolutely everything and can completely change how a case is going to progress. As you've seen from those case studies, you can look at an allegation and it can seem to be about one thing, and as soon as you put it into context, it changes. So yes, that's me just requesting that if you receive information about a notification from a member, you pass it on. Mark asked earlier about appeals, and I mentioned legal representation of members. So I just wanted to follow on from that about the representation that we provide. So once we start representing a member when an investigation started, we'll ask a member to sign the case handling protocol, and I know you'll all be familiar with the protocol. And from there on, we're going to support the member through their case. Now, as Jim said, the life of an investigation might be really short. It might end after officer review, or then at panel consideration stage and the next stage along. But a case could run all the way to a hearing. So as long, clearly, as the member complies with their obligations in the protocol, they keep engaging with us and they maintain their membership, we're going to represent them right through to the end of their case. Sorry, you can hear my wee alert there. Sorry. We're going to represent them through to the end of their case. So if a case does get to a hearing, Laura and I will stop being involved at that point. So we're both solicitors, we represent members. They get legal representation at an early stage, so submitting the response or submitting evidence in response to a report. But if a case goes to a hearing, we outsource our cases to one of our firms of solicitors that we use. There's only 2 of us, so we simply can't cover hearings as well as everything else. And the GTCS work is only part of our jobs. So we'll do the paperwork side of things if you like. We'll submit evidence as long as it's a paper-based exercise, but as soon as it goes to a hearing, people will still get legal representation, but it'll be from one of our solicitors that we instruct. And also, just to touch on the appeals point that Mark raised, as Jim noted, appeals on the outcome of cases are to the Court of Session. Appealing is really unusual. And it wouldn't just be where a member was disappointed, we would have to be identifying a perceived issue with the decision from a legal perspective, and then we'd have to assess the merits of the case. Also, all final decisions on funding from the EIS go to our Employment Relations Committee. It's really expensive to take an appeal forward to go to the Court of Session, and only certain lawyers have rights to appear in the Court of Session. So there's a lot of considerations around that in terms of actually appealing a final decision. However, I know Mark also mentioned raising issues around process, and as the process of a case develops, as a case progresses, if we spot any issues in relation to process, we'll just bring them to the GTCS's attention during the course of the case. We'll do so as we go, so it can be noted to the panel if we've got an issue with anything that's happened. So there are lots of kind of stages that we can have input for members, and we take those opportunities and make representations for members. So that's just a bit of extra information, but the only thing I'm asking you there to do is to pass on cases to us as soon as you get them. And the only other thing I wanted to touch on is the application that lecturers are making at the moment, the application forms themselves. There's questions in the form, and understandably, and that's how we're coming to the stage that lecturers are being investigated at the moment. There's some questions in the form that relate to previous disciplinary actions, previous convictions. Completely understandably, these things are relevant to fitness to teach. But some people might find those questions confusing or concerning, especially if they know they've been subject to previous actions from their employer or previous criminal proceedings. It's so important that the right information is disclosed in those applications in response to the questions, and that accurate answers are given in response to the specific questions asked. And there's questions about points that have relevance to fitness to teach. So if any member comes to you noting that they're struggling and they're not sure what they should be saying in the application or what they need to disclose, we can also support them there. So again, if you can direct members to our department, again, you can contact Lindsay for that, and we can provide some assistance there in talking them through what they might need to disclose on their applications. So all I'm asking really is a plea for 2 things. It's to get in touch if members are struggling with their application, and to get in touch if further down the road if members do find themselves the subject of an investigation. That's me.
Thanks, Sonia. That's great. That was perfect. Well done. And key thing there, speed is of the essence. As soon as something would come up, we get in touch pronto. Okay. Very good. There's a wee question come in here in the chat, which Probably for you, Jim. Sorry if this has been answered. If an issue is dealt with at a local level and the person isn't happy with the outcome, presume maybe a disciplinary might be